All right, hey, what's going on? Brian Jalbert here, actor, producer. We are getting ready to pop into a really great panel from the Hack in Hollywood Pitch Fest. This panel is with Barry Chase, with Chase Lawyers. Check his channel out at the end. I'm going to put a link in the description as well so you can find more information, because I'm telling you, after this panel, you're going to want to go to his channel and find out more if you're looking for this type of information. A lot of different things here. This is going to be for film and music. Either or category, you're going to want to check this out. Copyright, chain of title, derivative of work, fair use, work for hire. Are you a work for hire? Release forms, performance rights, composing rights. Maybe you got a book and somebody wants to option that book for a movie. Infringement of work. A lot of people worry about people stealing their work. What's the best way to copyright? Is it through Writers Guild or is it through .gov? He's actually going to talk a little bit about parodies and what you can get away with and what you can't. And then he actually talks a little bit about Barney, believe it or not, in this. So he got a chance. He was the vice president back in the 80s, he said, for PBS. So you're going to learn a lot from this. Again, it's Barry Chase with Chase Lawyers. So make sure you guys stick till the end to get his YouTube channel and find out more information about the film and music business. I'm Brian Jalbert, Hack in Hollywood Pitch Fest.
This is going to be a lot less fun than what you just heard. No, I'm going to try to. This is actually a very boiled down version of a 3-hour continuing legal education lecture that I gave recently to lawyers around the country. But I'm not going to do the lawyer part, what the lawyers got to worry about. But let me just talk first, just to jump right into it. You're in a field where copyright ownership, the ownership of the intellectual property, is how you make your money. The ownership and the marketing of the intellectual property. That's what it is. That's what a film is. That's what a TV show is. That's, in fact, what a screenplay is. That's what a book is. That's what a novel is. They're intellectual property. And all of them are protected by copyright principles. And by copyright, I want to make sure you understand. I'm not talking about the registration thing you can do on copyright.gov and pay $55 to the Copyright Office. I'm talking about knowing that you've got to be careful about your own chain of title, which means you've got to have documents because the Copyright Act says so. For any of you who bought or sold real estate, at somewhere in the process, somebody said to you, don't believe anything you hear that's oral, it's got to be done on paper. True in real estate. Just as true in copyright, for completely different historical legal reasons. But you are making a big mistake if you, for example, someone also asked me to say, this wasn't going to come from me because I don't like to pitch my own shtick. But don't go to a divorce lawyer to try to get advice on this. Don't go to a real estate lawyer or insurance lawyer. They won't know what you're talking about. Sometimes I have to negotiate with one, and it's a nightmare for me because I have to try to give them the whole background that they need. If they weren't lazy, you could actually get a lot of this stuff online at this point, or you could go to my continuing legal education courses. But the point is that it's a bad mistake to do that. You might want to get a name of an entertainment lawyer from your divorce lawyer, but don't use your divorce lawyer. So that's the last commercial you're going to hear from me. Now let me talk about what you get because you own it. You get the right to make derivative works. Now, what is a derivative work? A derivative work, I'm not going to read you a lot of law here, but a derivative work is defined as a work based upon one or more pre-existing works. Pretty simple, right? Derivative is a fancy word, just means something that comes from something else. What's that? Yeah, sequels are a derivative work of the original, but films are often derivative of books, of articles, of life stories, of what have you. Now, a lot of you are writing completely original material, but if someone wants to make a movie from it, then that becomes a derivative work, and you've got the right to control whether or not a movie's ever made from it. Also, let me just talk a little bit about the sleaze merchants who are in our business. I'm sure you deal with them all the time. Somebody comes to you and says, I want to option your film. And they'll throw names around. They'll throw Tommy. They'll throw everybody's name around, as if they hang out with them every night for dinner. You want to check things like that. You want to go to IMDb, for example, and find out whether this person's really ever done anything. I remember one of the things we left out of my exalted bio is that I was the vice president of the PBS network, the television network, for a while there in the 80s. And I had a lot of people who would come to me and say, well, I did. That's the wonderful word. I'm just trying to think, Cosmos, which was a series that, I forgot his name now, I can't believe it, but a series that thank you, that dealt with the Cosmos. And, somebody came to me at one point, a young guy, and said, I did the Cosmos. Well, I found that he basically brought coffee to the director of Cosmos. He did it, but he wasn't very important in it. So you've got to be careful about it. Also, simple things, by the way, and it's almost the first thing I do when one of my clients gets a proposed agreement. I go and check and see if the LLC that the other party is supposed to be really exists. Sometimes I know what state, sometimes I don't, but you can figure it out. You go to LA, you go to California, you go to New York, you go to Florida. If you can't find it in any of those places, you better start asking questions. It may be a dissolved company that the person had 15 years before and is still using the name. So those are important too because they indicate some sloppiness of thought or some sort of, a touch of fraud in what they're doing. So you want to make sure that what they do checks out. Now, let's see. Okay, from the point of view of the other party, they want to make sure you've got usually a copyright registration. Not necessarily, and after they know you, they may not ask. Go ahead, yes. Well, if you've got a team, you better have work for hire agreements from your team, because otherwise you're not going to end up owning it. The company that wants to own the intellectual property in your project has to own all of the intellectual property, because you can't try to sell the audio separately from the shots of the ocean. It's going to be merged into one whole work, and that is a copyrightable work. If you have people who are doing bits and pieces for you, you need what's called work for hire agreements from all of them. If they're independent contractors. And TV and film people don't usually have 20 people sitting around as full-time employees for the one film they do every 2 years. He did. If you didn't have a work for hire from him, he made the images. Well, it depends on what the contract said. There are certain sort of magic words. They don't have to be exactly the same words, but they basically have to say, well, I did. What's your name? Salvatore. Okay. I did this knowing that from the beginning it was going to be owned by Salvatore LLC, and all the results and proceeds are going to be owned by Salvatore LLC, and I don't expect anything more than what was written in this check to me. If all you do is write the check, it doesn't work. And I've had a lot of people do that. What the courts will do with that, not to get you too deeply in the weeds, is the courts will say, yeah, you paid this guy for his time, for his 3 hours, but where does it say you paid him for the results of what he did? Because that's a separate piece of property. So it's terribly important, and it's got to be in writing. It's got to be in an instrument that can be perceived by someone else. It doesn't have to be on paper, but what's that? Yeah, and it's sometimes a very tough lesson. Okay. Now, by the way, yes. If you all, I'm sorry, a Laker game. That's correct. What happens is that those royalties are collected by what are known performing rights organizations. It's also the way that composers, this is composers only, that composers, well, in that case, they're using the sound recording too. There are two copyrights in music. I don't want to get too far into music because it gets very complicated because of these two copyrights. But there's the composer copyright and there's the sound recording copyright. For example, the example I always use, old-fashioned, I'm an old guy, White Christmas. I'm dreaming of a white, right? Most everyone knows that, except for a few really young people who come to me and look at me blankly when I mention that. But that's been recorded 1,000 different times. You can go to the Copyright Office and see it. Kelly Clarkson did one a few years ago. There's still new recordings of White Christmas all over the place. But it was composed once by someone that probably only 3 or 4 of you know the name of, because it wasn't Bing Crosby who sang it in 1942. A man named Irving Berlin, which Steve knew, the composer who's here knew, but most people don't know that. So Irving Berlin wrote it. Irving Berlin's great-great-great-great-grandchildren are still going to Harvard on the checks they get from White Christmas, God Bless America. He composed a lot of things. But I didn't know that. Did he compose Happy Birthday? Oh, okay. Yeah. Whoever composed Happy Birthday, if it's still in copyright. So here's the story on that. If you're using a composer's property, because the composer just as Salvatore was saying, as soon as you put it in a tangible medium of expression, I'm very sorry to throw all this crap at you, but that's what it's called. It means something from which a third person or a second person can perceive it. So if you're singing in the shower, or you're thinking of a great movie scene in the shower, you don't own anything. You haven't created any new intellectual property. If you write down a description of it in a treatment, you've created intellectual property. Now you may not have created original intellectual property, but that's a sidelight. But it has to be written down, recorded in one way or another for it to become intellectual property, and then you've done that. Now there are 2 copyrights. The Lakers are going to be paying something called a performing rights organization for the performance of Who Let the Dogs Out. And if they're using a particular sound recording of that, because there may be many, I don't know. I'm only familiar with one. Who knows? If they're using a particular sound recording, they do have to pay the owner of the sound recording, which is typically a record company. Music publishers own composer copyrights. Record companies own sound recording copyrights. But that's too much music. Trying to stay with film here. Even though these guys left me with a chair full of garbage. All right. So maybe so. But let me go to a critical antecedent issue, fancy lawyer talk. But I've had clients come to me who talk about being approached by a filmmaker for an option on their book. The trouble is that their publishing agreement gave that right away to the publisher. So sometimes there's nothing you can do. They don't own anything. They can't negotiate it because the agreement. This one happened to deal with the University Press of Florida, and because the client was hard pressed for anybody to pick up her book at that time, the University of Florida managed to dictate the terms to her. So she didn't have the right to even negotiate this. So that's something that's out of a lawyer's control. Now, just to make sure that we're on the same page about what can be optioned, an article. It was a fascinating article about a McDonald's scam in, I can't remember where it was, the Daily Beast, I think. It was an 18-page article on Monopoly. You don't have to know it. But books, obviously, screenplays get optioned. And some people, I think, was it Tommy? I think you mentioned somebody making 6 figures, or maybe it was you, making 6 figures on optioning. I used to know a guy named Will Eisner, who was one of the great comic book illustrators until he died a few years ago. And I was making a project with him while I was running the PBS station in Miami. And he lived on options because he had created a character called the Spirit, who, interestingly enough, had no superpowers whatsoever, but was created during World War II and somehow became a sort of cult classic. And I think somebody has now done a movie on it, actually. Has someone done the movie? What's that? Sort of. It was not such a good movie. Yeah, well, not responsible for that. All right. Now, what are the advantages? Why does this option form exist, and what does it do? What the option contract will say is, okay, I'm going to give you just a little bit of money. I think $5,000 was mentioned before, for even it's something that I was negotiating with. Terrible. The guy who wrote Juror Number 3, Patterson, James Patterson. I was negotiating with his people over juror number 3. And the first offer that I made on behalf of my client, who was interested in optioning it, was $5,000. And they didn't laugh in my face. $5,000 now. Within 18 months, it's another $5,000 to extend the option period. Optioning is renting. Someone wants to rent your intellectual property exclusively for a particular period. And if they find a market for it, if they put together the kind of package we've been hearing about, then they may renew it, or they may purchase. They may actually exercise the option. And the exercise of the option will be stated either in terms of a flat fee, but more often in terms of a percentage of the budget, of a good faith budget. And at that point, the rights to make the derivative work, which you had as the creator of the underlying work, those rights go over to the whoever owns the option, because they have exercised the option. So it's an important thing to consider before you actually do that. And certainly, remember, you're tying your property up for 12, 18, maybe 36 months. And you can't entertain offers from anybody else during that period. So it's important to know whom you're dealing with. And we all know that there, particularly in Florida, I'm afraid, there are a lot of fast talkers who haven't done anything and who won't do anything. So unfortunately, you have to be very skeptical of it. You do have to go through these steps. If the person is dropping names, you might just see if you can't find somebody who can confirm whether they've ever met that person. And most often, the more names that are dropped, the fewer people they've met. But, not always, I say, but that's very often the case. So that's really all I want to talk about. If there's anything else that that was a 3-hour presentation if you were a lawyer. How awful was that, right? Let me just see if there's anything else. Not really. Not really. The rest of this was all about what a lawyer's role and obligations has to be in this kind of a setting. But yes, ma'am. Well, you own. To the extent that they are infringing some of what you created, if it's original enough, if all they get out of if all they do is have the car chase scene, that's not going to be an infringement on your film just because you got a car chase scene. It's a fancy French word for that. It's called mise en scène, which means basically it's trite. It's in every damn movie. So it's got to have an element of originality to it. But the question was, what's to stop them from just taking your premise or taking your idea, taking the central idea of what you've written, and just doing it themselves? And the answer is that it's an infringement if you've done something really original, and if it's almost identical. What happens a lot? I got 3 or 4 calls just this past week this way. Either music or something. One of them was film. But boy, I looked at a TV show. It was an awful lot like what I submitted to such and such 12 years ago. An awful lot is not going to cut it. It's going to have to be, the legal term is strikingly similar, which means almost identical. In music, that's particularly strict because there's 8 notes and there's the chromatics in between, and there's only so many rhythms, and and you're dealing with 3 or 4 minutes of material. So of course people build on other people's work, but in film as well. I mean, how many times have we seen car chases? So you can't count on that. But if you've got an original idea, and if someone makes something or takes something and tries to do something almost identical, then you've got an infringement case, which is a big mess. But and most people won't do it. One of the things that's why they will ask you, well, Writers Guild doesn't give you a copyright registration. Be careful about this. Writers Guild gives you the date by which you have completed the work. Writers Guild does not give you any government protection whatsoever because it's not a government agency. So you want to do the copyright filing. If you're serious about what you've got, it's $55. Even if you use me, it's only a few hundred. And I'll teach you how to do it the first time. I don't love doing them. So, we'll get on the phone together and I'll say, okay, go to this page, do this, click on that, set up your account with the Copyright Office and blah, blah, blah. And I'll charge you for my time once. But then I'm trying to teach you how to do it because it's dismal for me to sit there and do copyright registrations. Trademark is more interesting. Yes, sir. You mean in the same work? If it's a completed work and it's an integrated work, it's one copyright. Yeah, yeah. I mean that's all you need because it protects the entire work. Yes, sir. Well, they should have gotten work for hires for all that stuff. I mean, that's all solved by the work for hire agreement. You don't want to have to run around and get 40 signatures when the distributor wants to distribute your film. Well, yes, you can. If Disney's, if you've got an animated character, for example, you can get a copyright in that image. You can even get a trademark in that image, possibly. But that is separate from your ownership of the whole work, of the work as a whole. So that's really all. And yes, you had a question. Okay, yeah, I remember the title. Was it like Twilight Zone? Well, I don't know if it's in the public domain. Do you mean because it wasn't registered? And by the way, in, in the 50s, we were dealing in the 1909 Copyright Act. Despite my age, I'm not an expert in that act. The Copyright Act we're dealing with now was passed in 76, when I was at PBS actually working as a lawyer. And it became effective January 1, 78. But the 1909 Act had a lot of similarities, but there were things that were changed. For example, the requirement that things be in writing because judges were going nuts, having 45 people show up and say, "Oh, I was in the room when he said we should do X, Y, and Z," and the other guy says, "No, he didn't say that. It was the other guy who said that." So they made a nice clean break, and they said if it ain't in a document, then it didn't happen. It's not that you can't prove it; it didn't happen. Just as chain of title means the same thing in your profession as it does in the real estate profession. It means that you go back to the original inception of whatever the element was, and you see whether see whom it's been owned by, all the way up till yesterday, and follow that chain of title and make sure that when you're dealing with whoever you're dealing with, that person actually owns the intellectual property that you're about to buy for a lot of bucks. So it's something you want to do. Yes. Well, not just the distributor. Yes, that's right. Right. Okay. Language means a lot here. Your paperwork has got to say that in the event of non-payment of the final amount, the copyright transfer doesn't happen. Yeah. Yeah, of course. No, I mean, they look, lawyers, my colleague lawyers will use every quote trick in the book, yes. Hoping that one will work. Sorry, go ahead. Yes. Right, right. Now, fair use is really a copyright doctrine, but it's also applied in some ways in the trademark context. But fair use is narrower than you probably think it is. It has nothing to do with how much of something you may take. For example, George Harrison, famous Beatles type person. I hope some of you remember the Beatles. George Harrison did a song called My Sweet Lord, right? Turns out those were the same 4 notes of a song by, I can't remember the group now, a black girl group, as we used to call them, which was called He's So Fine. Same notes, 4 notes. That was it. He lost because those notes were so important in that song that that using the same notes for a new song was an infringement. So it's not true. There's a lot of conventional wisdom that's just wrong. You can take so much of a song, you can take so much of a film. Now, if you're doing a news broadcast, that's going to be fair use. If it's a legitimate news broadcast. What the courts really worry about is whether you're doing something that's going to invade the commercial productivity of the original. That's what there are 4 or 5 factors of fair use, but that's the one they worry about. Because that's what you're really talking about, is whether you have gutted the original creator's ability to make money on this. And because there are other contexts, where educational contexts, there's almost always fair use. Again, if all this stuff is bona fide. Now on trademarks, there's a lot of, you raised a very interesting question, because I just did a little, we have a YouTube channel, Chase Lawyer's YouTube channel, which I hope you'll eventually go to. We've got only 500 subscribers, but hey, that's not bad for boring lawyers. I just did one actually on shooting in a private place where there is a logo, a Coca-Cola logo or something in the background. That's not as settled as it ought to be. Whether you can keep that logo in, or do you have to blur it out? Just as it's not all that well settled, what we did in this case is we did 2 back-to-back little 3-minute things for the YouTube channel. One was I'm walking on the street and I'm talking about how these people behind me, they have no right to privacy. We don't have to blur their faces out if you're a filmmaker, because the standard is there a reasonable expectation of privacy? And if you're walking down the main street in Miami, there ain't no reasonable expectation of privacy. You're in a public place. We then turned the corner and we went to the lunch place that I like a lot, which if you ever get to Miami, you should go. It's a real Italian restaurant with a silly name called Soia e Pomodoro. But the chef is actually Italian, not Argentine. No insult to the Argentines, but most of the Italian restaurants that I find in Florida are not from people who are Italian. We go to this restaurant and they're shooting. I got a location release. That was the point of the thing. I got the chef owner to make believe he was signing a real location release, which would give me the right to shoot in the location, in a private location. But there were diners behind there. And you always worry about whether there's a couple back there, it's a guy having an affair with his secretary, his wife may see the YouTube video, and what are you doing with Madeline buying her lunch on Friday? So I advised my client, I advised us actually to blur that in an excess of caution. You have to worry about that sort of thing, because that was not a public place. You don't have to. It's well, it's always a good idea to get releases if you can get them, but sometimes it's overly awkward. Yeah, I mean, it's a great idea. Just as I tell my music clients at the studio entrance, I don't care if it's in your own basement or your own den or whatever it is, have a stack of work for hire agreements that the pizza man has to sign when he comes to you at 4 a.m, because he's going to come in. He's going to come in there, and you're going to say, "Here's the hook to our great song, blah 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 blah, Blue Moon." I forget that there was a real song called Blue Moon. And he sits there and he goes, "Hey, that's really terrific, guys, but I think it would be better if you said Green Moon," And you go, "Get rid of the pizza guy." Well, you change it later to Green Moon. He's told his girlfriend at 5 a.m, after he's finished his pizza gig, she's getting up to go teach school. He's told his then girlfriend, later his wife, that he did this. He tells her the adventure because it's much more interesting than delivering, pizzas to suburban households. He's in a recording studio, right? That's fun. So he tells his wife the story. 2 years later, the movie comes out, or the it could be a movie. The record comes out, and it's got Green Moon. And his wife says, "Hey, didn't you tell me you made that up for them? Did you tell me you changed that?" He says, "Yeah." She says, "Well, we just had a kid. We got to support the kid. Go see a lawyer." Now, however that might turn out, it's going to be all settled on the front end if he signed to work for hire. And that's true. I mean, I have a lot of trouble with my clients. I have a lot of hip hop clients. They may come to the recording studio with a whole posse of people, and or they even. It's the same problem I have when they come into my office, because everything you say to a lawyer is privileged, but not if someone you're not married to is sitting next to you and also hears the same thing. I have just initiated meaning canceled the privilege for that, and I can be forced to testify as to what I told you to do. So you lose that, and it's the same thing if you let people in who haven't signed to work for hire. You are taking the risk that later on, whether they're lying or not, they may claim a piece of what you think you created. Maybe in good faith, probably not. But they'll find a plaintiff's lawyer who, partly because it's a real estate lawyer, and is just thrilled to death to get into the entertainment space, and partly because they figure, aha, he reads the Copyright Act, and all that stuff, and he draws simple conclusions about it, and he thinks there's a pot of gold, and I get a call saying, "Well, I understand your client who just drove by me in his new Maserati has made $100 million on this thing. We want $100,000." And then you're in the soup. So don't take the risk. I mean, you got to do things up front. If you don't do them up front right, you can't fix them later. Like certain, just one thing, Tommy, and then I'll just finish this. The whole work for hire concept is that the two of you and whoever this independent contractor is, have agreed prior to the completion of the work that it's going to be yours. That's what the work for hire says. So if you don't do it right then, two things happen. One, when you go back to this guy who was your best buddy in high school, and you say, "Well, I paid you $500, but I need you to sign this new thing," he's going to say, I guess they got a big deal brewing here, so I think this time it's $50,000, not $500. That's one thing. The other thing is, a lot of courts, believe it or not, it's all federal, all copyright's federal. A lot of federal appeals courts, which there are 12 or so of them around the country, splitting up the country geographically, a lot of them will not accept that because the language of the Copyright Act does assume that you've done this before you finish the work. So a non-contemporaneous, fancy talk, work for hire is not always enforced. So we've developed a thing called this is really obnoxious, a nunc-pro-tunc work for hire, which is, it sounds great because it's Latin. It means now for then. That's all it means. And they will accept that. If you recite that we had this oral rather, not verbal. This verbal means ever pertaining to words, not ever pertaining to voice. And therefore a contract is verbal too, because it relates to words. But, a written contract. But you say you had an oral agreement, blah, 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 to do X, Y, Z, and this is just memorializing it later on. And if you can get the guy to sign that without charging you $50,000, it'll work. Yes, sir. Yes, this is something. If you haven't run into it, you will. Some of them won't even open the package. The most sophisticated ones won't open the package. They'll send it back to you, or may not accept it in the first place. But they want a record of it. The reason they won't open it is because, theoretically at least, well, the real reason is they don't think they're going to get something they never heard from someone they never heard of that's going to be of any value to them. They've got people, they've got their community of people that they work with. So that's one reason. The second real reason is because they really don't want something that comes in over the transom to be a big hit. Because what are they doing then? I mean, the whole point is they're on the staff or they're working, they're a reader, they're a script reader, whatever it is, and it's their job to be the traffic cop on that. So it doesn't make them look good if it's something that just came in and they had nothing to do with it from the start. The other reason, which is always the cover reason, and it's true to some extent, they may have something brewing in the back office that's a lot like it. And if they take it and read your thing, and then their thing shows up 2 years later, they're afraid they're going to get sued, because you will then be able to show that there are two things. If you can't show striking similarity, which is one standard, you've got to show access and copy. And that shows access. If they acknowledge they received your thing, they've had access to your thing. So they won't do that. And you know, there are smaller production companies that will, particularly if you're telling them that you want to work with them. One thing I tell unscripted TV producers, of which almost everybody is, every rich spoiled kid in Miami with a yacht thinks he should have a reality TV show, because his life is so cool. You know, it's so cool. There's great looking women around. You know, we're floating around in this $100 million yacht and all that stuff. Well, make it 40 million. It was only 40 million. Everybody thinks that their life is just really inspiring and so fascinating that everybody should be immersed in. So there's a lot of that comes in, and what I say to them is the same thing, and you can find this on the YouTube channel as well. I say you're going to have to associate with a producer who is known in your target network or networks. Preferably, you want to find a producer who's produced for several different networks that you're going after or streaming services, because they're not going to trust you. I mean, this happened to me even at PBS. You know, we weren't so interested in the bottom line, but I didn't want to have to depend on somebody I didn't know to deliver the show on time. If I was doing, you know, if there was a series, Carl Sagan, I forgot his name. If I've dealt with somebody before and I know they know our specs, I know they know what the timing's got to be, I know they know how to stick the PBS logo on the damn thing, I don't have to worry about that stuff. But if it's somebody I've never dealt with before, I'm not going to accept the project, even at PBS, unless they associate themselves with some really, it comes down to individuals. Some individual at some place that I trust. Okay, so anything? Yeah, we have a question? Are you allowed to ask a question? No, just kidding. Now, the parody has a specific definition in the courts. You not only have to make something that's based off of the prior thing, it has to comment on the prior thing. You said ridicule. That's certainly one way to do it. It's like a Pretty Woman and the Two Live Crew version of that. They were commenting, said the Supreme Court, and it went all the way up there, on the fact that Pretty Woman was sort of a naive song of the 50s, I think it was, and their song was cynical. Two Live Crew's song was cynical. So they were commenting on the unpardonable innocence of the first one. That's how the Supreme Court decided it was. But so it's not easy to do the parody thing. You can't just take someone else's tune, stick new words on it, and call it parody. It has to comment on the original. Now the soundtrack, you're going to hear from the composer. You're going to hear from, I don't know who owns the recording. You may not, you'll also hear from the filmmaker, I hope. Because as embedded in the film, the sounds of that music belong to the if it's ripped from the film, the sounds of that music belong to the producer, or the owner of the film, I should say, who may or may not be the producer. Okay, one last one, maybe? I don't know what time, we're supposed to be drinking here. Yeah, when I talked to Brian, I said, let me cut it short so we can get to the wine sooner. Yeah, go ahead. Great. Was she at Full Sail? Was she at Full Sail? No. Uh-huh. Well, it's whatever they want to call it, depending on how eager they are to get outside stuff. If their plate is already full, then you're not going to get a very hospitable reception. You need to find someone they sort of know. It's a little bit like what I just said about somebody making a series. They want to know that it's coming in through someone who's not going to turn around and sue them for copyright infringement, and who probably costs enough so that whoever is submitting it is serious. It's not just some. Although let me just say one other thing. None of us is perfect. I was the guy at PBS who turned. Do you guys know Barney? The Barney series, right? If you have kids, I turned that down 3 or 4 times at PBS. Until I got a call from the director of Connecticut Public Television, a guy I knew because I knew everybody, who said, "Boy, I've been running it in Hartford, and let me tell you, it's gangbusters, and you really ought to do it." And he was sort of leaning on me, and because the stations like Connecticut Public Television own the PBS network, I had to take it more seriously, and so Barney gets on the air. But no fault of mine. Fred Rogers was on when I got there, so I can't. Although I did meet him, strange dude. But anyway, all right. Yes. Oh, it's fabulous. Rod Serling cannot own an idea. You can't either. None of us can. It has to be committed to a perceivable recording of some sort, whether that's on paper or tape or whatever it is, before it's even intellectual property. And when you do that, you still can't own the core idea. You can own the expression of the idea. That's the distinction the courts talk about as if it's a clear, bright line, right? Well, you can own the expression of the idea, but you can't own the idea. So I can I can write a book about the South before and during the Civil War. I may or may not be able to have I can't use the same names as of characters as Gone with the Wind, but I could have similar characters because they were pretty much what was around in the South at the time and all that stuff. If I start using passages from the book, then I'm going to get in trouble. And these are difficult areas. These are good questions because fair use is a difficult area with gray area in it. I just had a client who came to me because this is actually a furniture company whose name you probably know in Florida, and they had written a book about their Cuban forebear who had come over on a raft in, I don't know, 65 or something like that, and his life story is what it was about. I didn't read the book. And they wanted to use shots that they had taken of his Greyhound bus tickets, because that's how he was getting around when he first got here. It's a $1 jillion company. And they made the mistake of submitting it to Greyhound. They didn't come to me before that, because I would have said, don't submit it to Greyhound. Don't give them a shot at telling you no, because then somebody in their lawyer's office has got a stake in trying to make good on that no. Just go ahead and do it, because it's fair use. And they said, and we have some shots of Greyhound buses pulling out with the logo. I said, that's also going to be fair use. It's just a passing shot. You're going to be okay with that. Trademark got involved in that too. But sometimes the best thing to do is not to do what a sort of respectable person would tell you to do. So don't ask Greyhound. Yes, sir. Yes. Shot from whom? Yes, if you want to buy someone's previously existing shot, you got to pay him for it. It's property, yeah. Well, that's a new one on me. Oh, well, that's a different story. Okay. I didn't know that someone was claiming, intellectual property rights in that sign, because it was a real estate deal sign. Yeah. I don't know. I would have to look into it, and for that you have to pay me my hourly rate. All right, I'd really like to wind this up. So nice. Thank you all.
Thank you so much, Barry. Great stuff, right? Let's give a big hand of applause to all of our speakers and all of our attendees. It's been a great first day of Hacking Hollywood Pitch Fest, right? We've learned lots, and it will continue tomorrow. So if you don't have a 2-day pass, you can still get a pass today for tomorrow. Tomorrow we're going to be speaking on making your first feature film or TV series, understanding social media. We have traditional and self-distribution. We have a film director panel, and we have another networking event. So the fun continues tomorrow. If you're not already signed up, sign up. Yes. And tomorrow, we will also be, for those that signed up for the Pitch Your Project, you will be pitching your projects. There was an email that went out yesterday. We're going to be resending it today, information on that. Call time for those that are pitching is 9 o'clock, and it's going to be in the Longboat, I believe is B room, but check your emails. Don't quote me on that. It's in the main building. And so, who's Mark, Adam, Tommy, Tom Malloy? Who else? Yeah. So read your notes that you received today. Read the document that we sent out in the email. It's really going to help you guys out. And I think that's all the housekeeping that I have now. One of the things that we heard today over and over again is networking, 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 and that's what we're about to do. So we have some appetizers in the back, we have a cash bar, we have this beautiful view, we have some of our speakers in our presence, meet locals and meet those that came in from out of town, and network, network, network. Thank you guys very much, and have a good rest of your night.